Hey everybody, wanted to talk about the difference between pre-litigation and litigation. So when we sign up a new file, it immediately goes to pre-lit or pre-litigation. And all that means is that a lawsuit hadn't been filed at that point. What we're doing during that period is we're gathering information, the client is treating medically, and when done with that, we put together a demand package that's going to include the medical bills, the medical records, photographs, if there's any experts involved at that point, like an accident reconstruction expert. All of that we put together into a demand packet that goes to the insurance company, and we try to settle negotiating the case that way in the beginning. If it becomes apparent through that process that we're not going to be able to settle for a number that we think is appropriate, or if they're not putting appropriate value on the case, then we talk to the client about moving the case to litigation. And that is where we actually file a lawsuit. And instead of dealing with an insurance adjuster on the other side, we're dealing with a lawyer and a law firm on the other side. The rules of civil procedure are in play, and we're getting the case ready to be tried. The vast majority of these cases do not make it to trial. But what we do and what we pride ourselves on is that when we take a case into litigation, we are working that case up as if we're going to trial. We are always prepared to go to trial. And the flip side of that is that we tend to get better settlement offers at some point in the case. Sometimes it's early, sometimes it's in the middle. A lot of times it's late before we go to trial. When we have a gun to the insurance company's head and trial is right around the corner is when we tend to get a lot of good settlement offers. But if you or somebody that you know has been involved in an accident, you've been injured and you need help, give us a call at the Dow Law Firm. We'd love to help you out.